Hello, my name is Jeff Sheridan. I'm an attorney and I practice in the areas of DWI and criminal defense here in Minnesota. You know, so much of what goes on in Minnesota's DWI laws happens in the shadows and is really designed specifically to trick drivers into forfeiting important rights that I've decided to do a little series of videos that I'm calling Minnesota's Dirty Little DWI Secrets. I hope you find that these videos are helpful and informative. Today's video is entitled The Vehicle Forfeiture Trap. Under certain circumstances, a car that the person is driving at the time of a DWI arrest may be subject to forfeiture to the police department involved in the arrest. That means that the state will actually issue a new title to your car, titling it in the name of the arresting officer's department. They can put cherries on the thing, use it as a squad car, sell it at auction, whatever. You have nothing to say about what happens to it. You're just left with the payments. That's the trick. Here's the dirty part. When the officer seizes your car, he hands you a notice titled a Notice of Seizure and Intent to Forfeit. And that document tells you that you have 60 days to ask for a judge to review the officer's claim that your car should be forfeited. It then describes the lawsuit that you are required to file within those 60 days. Well, what the form doesn't say is that if you don't also challenge the revocation of your driver's license in what's called an implied consent hearing, then the challenge to the forfeiture will be utterly useless. It also doesn't tell you that the driver's license challenge has to be filed not in 60 days, but in 30 days. So a person not familiar with how these various actions work together will be lulled into thinking that as long as I get this forfeiture thing filed within a couple of months, I'll be fine. And of course, by the time you file it, the vehicle is already the property of the police department. This is a vital piece of information that anyone facing forfeiture must know. And yet, despite the fact that you will walk out of the police station or the jail with a whole stack of papers in your hand, this information is going to be withheld. Don't fall into this trap. If you've been stopped for DWI and had your vehicle seized, you do not have 60 days to fight it. You only have 30 days. And you have to know how to serve and file that lawsuit within that time span. Don't delay. Contact my office at the number on your screen for a free in-person consultation with me. There's no obligation. I can assure you, you will walk away from our meeting with a much better understanding of this situation, having lost nothing more than a little bit of your time. Call now or visit our website at www.ssdpa.com.